My name is Muhammad Ahmad Pansota and I'm an advocate Supreme Court, and I've been practicing for the past 22 years, which mainly involves criminal and civil practice both. And I personally feel there are many enactments in Pakistan, there are many legislations in Pakistan. We are an excessively legislated place. And once we implement these legislations, effectively, they are bereft of ground realities. Now, I'm not saying that custodial torture is not a problem. It is a very big problem in Pakistan. But when these laws are made, these laws are not made with the point of view by keeping the point of view of a common man or how these are going to be implemented. These are, made in the utopian world, and based on that, we want to implement them. This is a fantastic law. Efforts were made to implement this law, but after the implementation, after this promulgation, I would say, the real problems begin because A, we have been unable to identify whether a common man has to approach FIA or police. Then the problem of convictions. So far, there is hardly any conviction on this subject. People are very, very afraid to take these issues forward. So I think because of these reasons, I personally feel it's a fantastic law on paper. But yes, as far as the implementation is concerned, there are several gaps between the two. देखिए, पाकिस्तान के आइन का जो सबसे मैं समझता हूँ खूबसूरत आर्टिकल है व्हेन इट कम्स टू फंडामेंटल राइट्स, वो आर्टिकल 14 है, क्योंकि वो ह्यूमन डिग्निटी को प्रोटेक्ट करता है एट एनी कॉस्ट. नाउ आर्टिकल 14 once again is one right that is not subject to any other right or any other law or any law, because generally when you talk about the fundamental rights, they're all subject to law: right to life, right to freedom of expression, and many other rights. But this particular right is not subject to any other law or right. So this is an independent right, meaning thereby the dignity of a man or a woman, of course in both cases, cannot be compromised under any circumstances whatsoever. Now the premise of this legislation of torture was Article 14, and Article 14 further traces its descent from the Holy Quran, because Article 227 of the Constitution says that all laws have to conform to the basic spirit of Islam. Now, when you look at it from the Islamic perspective, Surah Nisa talks in detail about how human body is to be protected, how human body is to be accorded that respect, which once again includes the protection from torture or any death leading to, out of that torture. So this was the premise on which this law was made. And I think this particular article has been very, very effective in terms of producing legislations or in terms of catalyzing legislations of such a sort. So yes, Article 14 का जब आप नफाज देखते हैं तो ह्यूमन डिग्निटी की जो सबसे आई थिंक एपिटमी है, जो सबसे बड़ी प्रोटेक्शन है, वो उसकी बॉडी के साथ टॉर्चर ना होना है या उसकी बॉडी की प्रोटेक्शन है. सो जहाँ तक तो आर्टिकल 14 का ताल्लुक है, आर्टिकल 14 हैज़ बीन ट्रेमेंडसली important and very, very, I would say, important in terms of the passing of this legislation. जो तो कानून है, उस कानून में जो इन्वेस्टिगेशनिंग एजेंसी है, दैट इज़ FIA. दूसरी इंपॉर्टेंट चीज़ ये है कि आपने एक शिकायत करनी है इस कानून के तहत और FIA को करनी है, और FIA बाय नाउ शुड हैव डेजिग्नेटेड दीज ऑफिसर्स, लेकिन इंटरेस्टिंगली FIA में अभी तक इसके ऊपर कागज़ और ये सब कार्रवाई हो रही है कि जी हम इन्वेस्टिगेटिंग ऑफिसर्स को बुलवाएं, प्रोसिक्यूटर्स को बुलवाएं, जिनको. सो वहाँ पर भी अभी पूरी आई थिंक द इंफ्रास्ट्रक्चर डज नॉट एग्जिस्ट देयर. सो एज वी स्पीक, जो पाकिस्तान का एक बेसिक शहरी है, उसका ख्याल ये है कि टॉर्चर जो है उसकी कंप्लेंट भी जाके हमने पुलिस को दर्ज करानी है. यानी आप इसका अलमिया देखें कि पहले वो टॉर्चर होता भी पुलिस से है मेनली, या अगर पुलिस का कोई ऐसा वाक़या हो फिर जाके कंप्लेंट भी उसने उसी को देते हो. कहते हैं ना जी, बीमार हुए जिस उसके सबब उसी अतार के लौंडे से दवा लेने जाते हैं. सो ये बेसिकली इज वन एंड द सेम थिंग. सो पीपल जनरली डोंट नो वे टू कंप्लेन इनिशियली. सो द कंप्लेंट हैज टू बी फाइल्ड विद FIA. FIA विल देन टेक अप दैट कंप्लेंट, इन्वेस्टिगेट करेगी, एंड FIA बीइंग अ स्पेशल लॉ, उसमें इन्वेस्टिगेशन के बाद इट लीड्स टू रजिस्ट्रेशन ऑफ अ केस, एंड बेस्ड ऑन दैट इंक्वायरी वंस द केस इज रजिस्टर्ड, एक ट्रायल चलता है और फिर इवेंचुअली इसमें ऑफ कोर्स कन्विक्शंस होती हैं. सो यहाँ पर जो बुनियादी तजाद है जिसका अभी तक कोई हल नहीं निकल सका, वो यही है कि लोग पुलिस के पास जाते हैं, पुलिस उसको सीरियसली नहीं लेती. देयर इज रिफ्यूजल फॉर रजिस्ट्रेशन ऑफ केसेस, देयर इज रिफ्यूजल ऑन पार्ट ऑफ पुलिस टू फर्दर sort of forward it to FIA, because of course अपने खिलाफ कोई क्यों एक्शन लेगा. सो इन तमाम फैक्टर्स की वजह से लोग अभी प्रॉपरली बेचारे इस काम में नहीं डाल रहे. पाकिस्तान के जिस कानून को आपने रिडंडेंट बनाना हो उसके अंदर एक अब डाल दीजिए कि अगर कोई झूठी कंप्लेंट करे तो हम उसके खिलाफ एक्शन लेंगे। मेजॉरिटी ऑफ द पीपल हु आर सब्जेक्ट मैटर्स ऑफ दिस लॉ और पीपल हु आर विक्टिम्स ऑफ दिस लॉ आर पीपल फ्रॉम द पुअर स्ट्राटा और फ्रॉम द लोअर मिडिल क्लास और फ्रॉम द लोअर क्लास, expecting them to take on a police officer or a senior police officer or some other police officer and then not being able to or not be able to prove that complaint is a big challenge for them. So it is, I think, because of this provision alone that you don't see too many people filing these complaints. And eventually क्या होता है, वो बेचारे उसको बर्दाश्त करते हैं, बैठ जाते हैं। इसी किस्म की चीज़ एक सेक्सुअल हरासमेंट के कानून में भी थी। सो लोग डर जाते हैं कि हम कंप्लेंट करें, कल को प्रूव ना कर सके तो ये प्रॉब्लम है। I think it's very important for the lawyers of this country to first understand what this law says. Because I cannot be in a position to explain this law unless I know the law inside out. So I think there is a very grave need to give awareness about this law, the constituents of this law, the provisions of this law, how this law is to be implemented. Then lawyers have a duty to further talk about this law. I mean, this is, I think, part of the process that we are talking about this law. So when people will see this video or when people have access to the information, then they will, of course, file complaints. And this is exactly the problem which occurred with the sexual harassment law as well. People did not know, or females generally didn't know, that they have an avenue to explore, that they can explore in terms of filing a complaint against the like some harasser in terms of sexual harassment. So similarly, I think awareness is very important. I think a very important role lies with the prosecution. This is also another problem that arose when people or police officers were investigating cases of rape victims or rape cases. And there, I believe in 2012, there was a specific judgment from the Supreme Court of Pakistan, which eventually led to passing of finally the Anti-Rape Act. I was part of the Anti-Rape Act committee, and we were able to formulate these beautiful provisions which are now being implemented. So similarly here, there have to be specific rules on the subject, how the prosecution is to be done, how is the medical sample to be collected, how is it important for a victim to go and approach the concerned medical officer to get his medical done, because usually torture, if you don't get your medical done within days, then it withers away or the marks wither away. So it's important for the government to legislate in form of rules, and these rules must be implemented explaining all of this. As far as international treaties are concerned, as far as international arrangements are concerned, I think we all need to be cognizant of the fact that these have a persuasive value, they have a binding value if they have been ratified. So first of all, when you're taking matters to court, because a lot of the cases, they eventually result in filing of writ petitions. You have to invoke the jurisdiction of the court. Let's say, I'm giving you an example, you file a complaint, the complaint goes before the police officer and he's not willing to act, then you file a writ petition before Lahore High Court or any other high court, and then court will direct the concerned officer to relay that information to the concerned agencies, which is the FIA in this case. Similarly, leveraging these international instruments, when you are making these submissions before court, it is very important to bring in these instruments. You talked about UNCAT, and then you talked about the Istanbul Protocol. I think both these laws have different significance. As far as the Istanbul Protocol is concerned, it relates to how the how the investigation is to be done, how the matter is to be taken forward. Similarly, UNCAT, Pakistan is a signatory which says that you have to end all forms of torture. So when you look at it from that point of view, especially with the inclusion of these arrangements, I think it becomes easier for a judge to give binding directions to the concerned law enforcement agency. I think Pakistan is a country where majority of important laws have developed through public interest litigation. I can refer to judgments like Askar Lagari. I can refer to my own judgment, Muhammad Ahmad Pansota versus Federation, where a law on the food was developed. So you require these judgments from time to time to set the law into motion, or to set the law into motion in a more appropriate way. I think similarly, lawyers who have the position, have the authority, and can spare time must take up this law and it should be brought before the courts. And I think there was a challenge which was made to this, not the challenge, there was a petition which was filed before Lahore High Court where it was sought that, directions should be given to the concerned authority to implement this law, because this law is not being implemented. So I think we need such similar challenges where all of these international instruments are reproduced, where all the international best practices are reproduced, and then you expect from the courts in Pakistan to give a proper meaning to that legislation. You see, laws are there. It's not that simple to implement a law, but then you require these judgments. These judgments were pronounced on the Anti-Rape Act as well. There were judgments by Justice Alizia Bajwa, Justice Amjad Rafiq, and so on and so forth. Similarly, on this law, you require 2 or 3 pronouncements, and I believe lawyers should take it up. In my personal capacity, I would love to do it, and I think because if I do public interest litigation, I must take it up and take it to court, because there are several loopholes in the law that must be brought to court's notice, and courts must pass authoritative judgments or pronouncements to make sure that is clarified. As far as the concept of binding precedent is concerned, all lower courts in the country are bound by the precedents of the superior courts. Article 189 of the Constitution is very clear on that. In as much as they decide a question of law, so that it becomes important. Here, the judgments of High Court have to be followed by the lower courts, and if they're not following it, that's basically a violation of the law. So yes, when these judgments come into play, then it becomes a roadmap for these judges who are conducting trials of these cases. So it becomes a roadmap for them, and it becomes all the more important for these superior court judges, which includes High Court and Supreme Court, to clarify these subjects, so that if there is any anomaly, that should be clarified, and the trial court judge is in a position to implement that. This law ki intent is very clear. You want to give protection to somebody who's been a victim of custodial torture. Number one, you have to make it easier for him. So there has to be a complaint mechanism. The rules must clearly state how the complaint is to be made in writing. Can it be made online? Can it be a secret complaint? The identity can be protected or not, number one. Number two, the prosecution and the investigation has to be very clearly defined. This is exactly what we confronted in Anti-Rape Act, and we were able to make some very good rules. Thirdly, medical. How the medical is to be taken, how a medical sample is to be collected. Then especially a specific procedure has to be prescribed for the females, because females also encounter custodial torture, and that process has also been, you've done the homework before in the case of rape, in cases of many other laws, so that can always be borrowed and adopted. So yes, rules. As far as the main law is concerned, I think I am not too happy with the provision where if you file a false complaint, you can be penalized, because it is very easy to simply state that the complaint was false, and just because you're unable to prove it doesn't mean that the complaint is false, right? So I think that provision has to be mellowed down, or at least removed from the law at this point in time. कानूनी बरादरी की सबसे इम्पोर्टेंट जिम्मेदारी तो ये है कि इस पर सेमिनार्स करें। फिर ये ज़रूरी है कि जो कानूनी बरादरी में से इस पोजीशन में है, किसी अच्छी जगह बैठा हुआ है, कोई लेट से लॉ मिनिस्टर है, कोई सेनेटर है, कोई कुछ है, वो इसके ऊपर बात करे, असेंबली में इसके ऊपर बात की जाए। और ये जो टॉर्चर वाला मामला है, ये सिर्फ कोई अब इस वक्त लोअर स्ट्रैटे का इशू नहीं रह गया, ये तो हर जगह टॉर्चर हो रहा है। Custodial torture is a very big issue, and it is not only restricted to a particular class, which used to be an issue before when this law was made. Now it is an issue which is being confronted by Pakistanis as a whole, or generally all the classes of Pakistan are sort of in that position. So I would say कि वुकला, politicians, civil society, इन सब का बहुत important role है कि लोगों को पता लगे भाई ये law exist करता है, and you have every right to invoke the jurisdiction under this law.